Today, I'm thrilled to share another exciting thought-provoking video that's going to make waves. A short history of English law from the earliest times to the end of the year 1919. Chapter 1. If you're into deep dives into society, equality, and the future, this one's for you. Ever wondered about the foundations of our social fabric? Join me as we unravel the intricate layers of the social contract that shapes our world. Let's challenge our perspectives and explore the implications of its termination. To spread the word, let's start a ripple effect together. Share this video, tag a friend who loves intellectual conversations, and use hashtag #SocialContractUnraveled and at Equity Exposed to join the movement. Let's ignite a dialogue that has the power to reshape our understanding of society. I hope you enjoyed yesterday's video, a sketch of legal history, Chapter 1. Did you catch the concept of jurisdiction? Did you notice jurisdiction started as voluntary? The settlements of today consist of titles. Titles are equitable rights to things that another owns. During the time of pre-English, jurisdiction was created by taking or wanting a thing or property of another that belonged to that ruler or king. What creates modern jurisdiction is the individual wanting property in the possession of another that has a higher or better right to it. This property of another scheme is the start of tenure law today. The English law system ushers in a system of land as dominion, where the king is the ultimate owner of lands and the subjects get a property interest. Today's video will shed a little more light on pre-English law. Then we will start to look at the start of English law in 1066, the usurpation of England, which is the beginning of almost 700 years of despotic rule under a tenure of land until a constitutional monarchy is appointed 1688. A short history of English law. From the earliest times to the end of the year 1919. By By Jenks, M.A., B.C.L. Of the Middle Temple, Barrister at Law, Principal and Director of Legal Studies, G.F. The Law Society, England. Second edition, revised. Preface to the second edition. Most of the changes in the law which have taken place since this book was first published are either of a temporary character or deal with the constitutional side of legal history, with which, for reasons stated in the preface to the first edition, these pages do not profess to deal in detail. But changes produced by the war which are intended to be permanent have, so far as they affect other sides, been, it is hoped, adequately noted, and opportunity has been taken to correct a few errors and misprints which appeared in the first edition. Marg. 1920. Preface. Axuti 10 years ago, Messrs. Methuen and Company approached the author with a proposal for a History of English Law in one volume. The interest aroused in a long-neglected subject by the brilliant work of the late Sir Fitzjames Stephen, of Sir Frederick Pollock, of Mr. Justice Holmes, and, above all, of the late Professor Maitland, to say nothing of others whose contrary battalions, though more fragmentary, were profoundly interesting, had convinced most teachers of English law that a rich field of educational effort awaited development. Unfortunately, the scale on which the writing of these authors was planned rendered them unsuitable for the average student, whose time was limited, and it was felt that the subject could hardly take the place which it deserved in the ordinary training of the lawyer, till some more modest, but comprehensive, manual had appeared. At the time when the approach referred to was made, the author's time was deeply pledged in other directions, and he doubted also whether the moment had then arrived at which the state of available knowledge rendered such a work possible. He therefore suggested an application to his friend Dr. Holdsworth. As is well known, that application was not made in vain, and the world is today the richer by Dr. Holdsworth's 3 volumes. But, in the hands of Dr. Holdsworth, the work has proved to be something very different from what was at first contemplated, and the plan for a single volume has developed into a scheme of which the first 3 volumes bring us down only to the end of the 16th century. Meanwhile, largely owing to the labors of Professor Maitland and other contributors to the noble series of volumes produced by the Selden Society, more material has become available, while the recent publication, the fruit of American enterprise, of the 3 volumes of select essays in Anglo-American legal history, has further stimulated interest in the subject. It seemed, therefore, to the author that the time had at last arrived, at which Messrs. Methuen and Company's original idea might be realized, and he ventured to approach them with a Suggs tie-in for a revival of the plan. It was, of course, obviously due to Dr. Holdsworth that his concurrence should also be obtained. In both quarters the response was prompt and cordial, and Dr. Holdsworth, with great generosity, further offered to read the proof sheets of the intended work and give the author the benefit of his criticism. Thus the way seemed clear, and the present book is the result. As space was limited, the author has touched lightly upon that side of our legal history which has already been made the subject of adequate treatment, viz., the origin and development of the courts, and the relations of the state towards its subjects. These can be found conveniently summarized in Professor Maitland's posthumously published constitutional History of England, in the first volume of Dr. Holdsworth's History of English Law, and in Dr. Carter's English Legal Institutions, as well as in the many other useful treatises on constitutional history. But with this exception, the present volume attempts to cover the whole field of English legal history from the earliest times to the present day. That this is a sufficiently ambitious attempt, no one can be better aware than the author. Though he has made no statement which he has not verified from original evidence, he has, naturally, availed himself to the full of the work of previous writers for the earlier part of his task. But, from the end of the 16th century, he has sailed over an almost uncharted sea, and his responsibility is great. He can only plead that he has kept a careful lookout, and that he has striven faithfully to sail the ship in the main current, without attempting to enter the bays and inlets, which to have explored would either have prolonged the voyage to an undue length, or have neglected the essential for the picturesque but less important. One other word as to the plan of the book may be permitted. An American correspondent, whose reputation as a teacher and writer stands high, has urged upon the author the adoption of what is known as the vertical method of writing history, by which the development of each existing institution is separately traced from its origin to its present form. After long reflection, the author felt it impossible to adopt the plan proposed by this suggestion because, in his view, it would either involve almost endless repetition, or it would obscure one of the most important lessons to be learnt from English legal history. For, if there is one truth which that history makes more clear than another, it is that the sharp division into distinct subjects which is so familiar a feature of a modern and highly complex system of law, finds no place in its early stages. Property, contract, tort, crime, even the apparently fundamental distinction between substantive law and procedure, are not recognized by primitive people. The germs of all these ideas may be detected in early law by the microscope of the expert, just as the future stem, tendrils, leaves, flowers, and fruit may be detected in the seed of a plant. But one of the most valuable lessons to be learnt from the study of the growth of a native and independent system of law like the English is an appreciation of the processes by which these specialized ideas have slowly detached themselves from those primitive notions of right and wrong which are the kernel of all systems of law. So the author has adhered to the old-fashioned plan, dividing his subject into historical periods, marked by events which seem to him to be milestones on the ever-broadening path of legal development. It remains only for the author to express his grateful thanks to those whose labors have rendered his task possible of achievement, if indeed it has been achieved, and to commit his work to the judgment of the public. To Dr. Holdsworth, who, as has been stated, has been kind enough to spare the time to read the proof sheets, his thanks are most especially due. It is needless to say that he has benefited greatly by Dr. Holdsworth's suggestions, and, where he has not been convinced by them, he has, doubtless, been wrong. As for the work, the author will be more than satisfied if his attempt encourages others to do better. He makes, of course, no claim to completeness. His hope is only that he has shown some sense of proportion and an essential reverence for the truth, which will not be found without their uses. In a word, his aim has been to stimulate, not to satisfy. Lawn Pond, April, 1912. A Short History of English Law. Chapter 1. Old English Law. T is the glory of English law, that its roots are sunk deep into the soil of national history, that it is the slow product of the age-long growth of the national life. A few words, therefore, albeit diffident and cautious, must be said in this book of that dim period in which the foundations of the national character were laid. As years go, it was a long period, lasting little less than 6 centuries. During those long years, English men lived and died, married and begot children, fought a good deal and brawled more, were convert from heathendom to a rather secular Christianity, built a few petty towns. But, for the most part, their lives were occupied with clearing and tilling a fertile and well-watered country, whose very fertility was a source of endless labor. For the English settlers found vast forests to be cleared before the soil would begin to yield corn or pasture. The record of those long years is in the smiling fields of modern England, whose remotest village seems, to the visitor accustomed to the rough farming of virgin lands, like the garden of some lordly pleasure house. Some few chronicles of this dim time have survived to us. But of laws and institutes we have little, and that little is obscure and untrustworthy. The so-called Anglo-Saxon laws date from a well-recognized stage in the evolution of law. They reveal to us a patriarchal folk, living in isolated settlements and leading lives regulated by immemorial custom. Whilst there are certain features common to all of them, showing us a society to some extent homogeneous, they differ in detail from one petty kingdom to another, almost from one village to another. Therefore, it is very hard to base any general statements upon them. More serious drawback still, the longer one studies them, the more one suspects that they deal rather with the novel and uncertain, than with the normal and undoubted rules of law. That is, after all, natural, for, among primitive people, the process of law-making or law-declaring is painful and laborious, only to be resorted to under severe pressure. Why trouble to record that which every village elder knows? Only when a disputed point has long caused bloodshed and disturbance, or when a successful invader, military or theological, insists on a change, is it necessary to draw Eupicode. That is practical sense, but it has its drawbacks for the student of legal history. Still, the student must be grateful for the Anglo-Saxon laws. In some respects they are unique. Some of them are very archaic character, pointing to a society not far removed from utter barbarism, whose women and slaves stand on the same footing as cattle and sheep. Most of them seem to have been drawn up in the vernacular, whereas the corresponding leges, barbarum of the continental Germans were, almost invariably, recorded in Latin, probably by Italian scribes. Consequently, the Old English laws are more likely to be true pictures of life than codes like the Lex Salica, which, as the famous Malberg glosses suggest, was translated by its compilers from an uncouth tongue which they failed to understand. A much debated question stands at the threshold of our story. How far are we justified in assuming that our English law is of English origin? England was settled by other tribes before the English arrived. Those tribes had a civilization of their own. They were conquered by the Romans, who governed them for centuries. Those almost prehistoric centuries were the golden age of Roman jurisprudence. Before the oldest of the Anglo-Saxon codes was drawn up, Justinian's monumental Corpus Juris had been given to the world. When Edward Longshanks conquered the Welsh in the 13th century, his officials held an inquest which revealed a highly organized system of tribal land ownership, and this system may, though that is by no means certain, have dated from very ancient British times and once have prevailed throughout Britain. Once more, the Anglo-Saxon laws bear evident traces of ecclesiastical influence. Ethelbert's Code was drawn up on St. Augustine's Day. Are we to suppose that nothing found its way into them from decrees of councils and synods, though the days of a refined canon law were yet to come? Each branch of this inquiry is matter for specialists, and none can safely yet dogmatize. Only it may be pointed out that a rough and ignorant people like the English, noted from of old for their sullen aloofness from the wider world, would not be very amenable to foreign influences, that they would hardly be likely to borrow much from the conquered Welsh, from an emperor at Constantinople, or even from an Eastern council. Such outside influences as did penetrate into primitive England came, probably, from household slaves, some of whom might be captives of superior education, from provincial versions of the Theodosian Code, or from the penitentials of the mass priest. It is doubtful whether Justinian's legislation was generally known in Western Europe before the Norman conquest. First we notice that there is no equality before the law. A man's rights depended both on his social rank and, in some people's cases at least, on the custom of his neighborhood. Eke in various apocryphal documents drawn up after the Norman conquest, we see clear traces of a status system, which, though it was giving way, long continued to dominate English society. The noble by birth, Jarl, Atheling, Gesith, natural product of pure patriarchal life, had almost disappeared. He survives in the older laws as protected by a special warguild. Probably, if analogy is to be trusted, he was maintained by special gifts from his fellow tribesmen, entitled to feast at their houses and to be clothed with the finest produce of their looms. The Searl is the typical farmer. If we call him free, we import modern ideas into primitive society. Probably he was not free in the sense that he could throw up his calling and go where he liked. With equal probability, he had no desire to do so. Ably he paid some tribute. So does the modern free citizen. Certainly he was liable, or should we say, entitled, to military service. On the other hand, he had probably a substantial claim, by the mere fact of his birth, to a share in the land of his village, and his life was protected by a warguild which was, almost certainly, payable to his kindred, and not, even towards the end of the period, to his lord. Below the Searl came a class whom we may fairly call unfree, in the sense that they were treated more as property than as persons. Doubtless, as some of the names given them imply, they were not mere domestic slaves, herded together in their lord's house, but were allowed to occupy cottages and, probably, patches of land. But, in the period of which this chapter treats, they were marked off from the Searl by the facts that they did not serve in the host. They had no place in the mood, and that violence to their persons, though it was punishable, brought them no personal compensation. The man bought of the unfree went to his lord. The many names, Theo, Esne, Late, and C, by which this class is described in the Anglo-Saxon laws, seem to point, not merely to differences of race, but to differences of legal standing. Still, no conclusive solution of these problems has yet appeared. Most important, for legal purposes, is the class of thanes, which, apparently unknown or little important in the earliest days, from the end of the 9th century rapidly acquired a prominent position. The origin of the thane is matter for general and constitutional history, but it must be noticed that, from his earliest mention in the codes, he is specially marked by signs which rapidly become characteristic of later law. He is peculiarly connected with the royal service. All thanes are servants, as their name implies, but the king's thane overshadow the others and tend to exclude them finally from a class which is rapidly becoming of special importance. Service, with the thanes, at any rate with many of them, was peculiarly associated with landholding. We shall probably not be wrong in identifying the thane with the land, Rika or Landlafford, who appears as an established institution. From the time of Ethelstan, exercising jurisdiction in matter of purchases, collection of tithes, accusing of criminals, and other functions of local authority. Of his relation to land ownership, something more must be said when we come to deal with that subject. But we cannot here part from the thane without noticing that through him the rule of forfeiture for misbehavior seems to have come into our law. The thane who deems an unjust doom is to lose his thaneship. It is a principle which can be widely applied. In matters more strictly legal than the organization of society, we note at first, apparently, an almost entire absence of that exercise of state authority which, at the present day, is regarded as an essential of civilized life. This is specially remarkable in that branch of law which to us seems the peculiar province of the state, viz., the administration of justice. Nothing can be clearer than that, in the earlier part, at least, of the early English period, the action of the state, or even of the local authorities, in this matter, was only invoked in rare cases and with great reluctance. The oldest form of redress for injuries suffered is personal vengeance. In one sense it is, of course, illegal because it is not regulated or formally sanctioned by the state. In another it is not, for there is, in the earliest days, no law against it. Moreover, whatever public opinion may then have existed regarded it with toleration, if not with actual approval. The first restriction comes with the feeling that indiscriminate vengeance is intolerable. The man who has been wounded by a chance arrow must not shoot at sight the first man he happens to meet. He must make some attempt to identify the aggressor. If the wound proves fatal, the relatives of the slain may avenge the victim. But they, too, must not slay indiscriminately. They must restrict their vengeance to the murderer and his kindred, who may be supposed to be sheltering him. If an ox is stolen, there must be some attempt to track it. The trail must be followed until it leads to the stall of the thief. It is not permissible to seize the nearest beast to replace the loss. If the track leads to the thief's stall, but the stolen ox cannot be found, the pursuer may seize a beast belonging to the suspected thief to compel the return of the stolen ox. But he may not make good his loss at the expense of his peaceful neighbor, who has done him no wrong. There is abundant evidence in the Anglo-Saxon laws that the feud, the fresh pursuit, and the distress, ma'am, were perfectly familiar to the compilers of the codes. There is also evidence that the wiser members of the community, supported by the kings, were anxious to modify and, perhaps, ultimately to suppress them. Not only do there appear numerous attempts to restrict the feud to its narrowest limits, it is to be levied only against the actual wrongdoer and his harborers. The right of sanctuary is to be respected, and on peace days hostilities are to cease. But the laws aim continually and earnestly with minute care to persuade the aggrieved party to accept the blood fine or wargild in lieu of corporal revenge. At any rate, if the wrongdoer does not attempt further violence, right must be demanded of him before the ancient claim of vengeance is enforced. So also, even if the stolen beast is tracked, the person with whom it is found must be given a chance of proving his innocence. He may have bought it in an open market before proper witnesses. And so the picturesque process of intertiatio or anafang is enjoined after a formal claim has been made. The beast is lodged with a third person to await the issue of the dispute. Only with the advent of a strong monarchy was it possible to stamp out the extrajudicial distress, or at least to confine it to claims by a lord against his vassal. In later days, the process of vis de nom became one of the most important in the legal armory, and the remedy of replevin curbed even the privileges of a lord. What exactly happened if, as the result of these attempts to substitute legal procedure for self-help, the hot blood cooled, and the parties made to swear the peace, it is very difficult to say. Mr. Bigelow, arguing from the evidence of the next period, and founding himself on the very reasonable assumption that the Norman procedure took over a good deal of the pre-Norman, has attempted to construct a sort of general picture of a primitive English lawsuit. But the subject is beset with difficulties, for of contemporary evidence there is little or none, if we accept the few forms of oath and the fragments of the ordeal ritual which survive. Generally speaking, it may be said that the formal proceedings commenced with the pronouncement, by the elders of the moot, of a doom which specified the penalties for the alleged offense, and settled the very important question of the onus of proof, or, as it ought perhaps, according to the ideas of the day to be called, the privilege of proof. And so we are not surprised to find that denial is ever stronger than claim, for the proof was not what we should understand by evidence at all, but merely a general denial of the accusation by the accused and his oath helpers. Generally speaking, if the accused was of good character and the circumstances were not overwhelmingly against him, a day was set for the performance of this ceremony, and, if it were successfully accomplished, with due number of helpers and due observance of technicalities, the accused was acquitted. But if the accused were typweisig, of bad character, or if he had been taken red-handed, he was put to the severe test of the ordeal. What happened in either case if the accused failed to clear himself is also a matter of no little doubt. Probably he or his relatives paid, or gave security for, the proper wargild without further dispute. If he or they were still obstinate or too poor, The feud which these proceedings had attempted to scotch revived, and the injured party or his relatives, if sufficiently strong, exercised the ancient right of corporal vengeance. Even at the end of this period, the local moot seems to have had no executive power whatever, and the royal action, if it applied at all to private lawsuits, was confined to IHE's simple step of compelling the accused to come before the moot in the first instance. To secure his reappearance, it was necessary to take security from him, either by pledge, wed, or by bail, bor. In all this process, the action of the state, the central government was, as has been said, very small. But there are signs that, even in this remote early English period, the royal officials were beginning to play a larger part in the administration of justice. They probably approached the matter, first from the side of revenue, then from that of police. From the days of Ione, at least, the ceorl who neglected his military service paid fyrwhite to the king in the reign of Edward the Elder. We see traces of the offerherns, or special fine to the king for disobedience to the royal command, which was, apparently, often used to support the authority of the local moot in the adjustment of disputes. But the claims of the king soon went still further. Doubtless the ordinary offense, even the violent offense, was looked upon, primarily, as a wrong to the party specially wherein injured, and his kindred. Yet there are traces, in almost all primitive law, of peculiarly detested acts, which the community takes upon itself to punish by some form of communal vengeance. The interesting survival of the derricade, described by Mr. Round in the communes of the 12th century, may or may not be primitive, but it is clear that very primitive people draw a distinction between a merely festive murder or robbery and an act aimed directly at the security of the community, such as tampering with strangers against the common interest or putting a spell on the common fields. In its modern form of lynch law, the same interest still manifests itself where the state is weak. The vengeance of the community is, however, slow and unorganized. A great step is gained when the king takes its place. Not only are Betlia's offenses more promptly punished, but the list of them can be indefinitely extended. The change was clearly marked in England by the time of Nut. By the time of the conquest, the list of the king's rights had greatly extended. Thus the land saw the beginnings of a true criminal law. A man accused on such a charge had no right to the elaborate privileges which stood between the private accuser and his prey. Until the Assize of Clarendon, in the next period, introduced something like a true criminal procedure, he was lucky if he could obtain some PLE and summary method of trial, probably by ordeal. It was centuries before the person accused at the king's suit secured what would now be considered the elements of a fair trial. It is only indirectly, and through unintentional hints, that we can detach from the heap of unsystematic dooms which make up the Anglo-Saxon laws any hints of a law of property. The existence of ideas which will someday produce the notion of property, or at least of possession, is to be found in the recognition of theft as an offense, and in the reluctant allowance, under stringent safeguards, of the sale of cattle. It is clear that, in fact, many other articles, e.g., garments, armor, and weapons, and, presumably, threshed corn and ale, were known to our pre-conquest ancestors. But the fact that the word chattel has survived as the inclusive legal term for all movable goods points not merely to the great importance of cattle in primitive times, but to the importance of the notion of sale or barter in generating the institution of property. Apparently, the laws do not regard other goods as transferable, except, perhaps, for special purposes such as the satisfaction of wargilds and, obviously, the man who was found with a beast bred in another man's stall was, prime facie, a thief, if he wished to clear his character. He had to name the man from whom he bought it in open market, and this man must take up the burden of the charge, or fight the man who has vouched him to warranty. In this process of vouching to warranty, there was much that influenced the law of property in later days. In the oldest time, it was, primarily, a means of escaping a charge of theft. Still more reticent are the Anglo-Saxon laws on anything that relates to land ownership. In one famous passage, land, regarded as a subject of property, is divided into East Sealand and Falkland. The division may or may not be exhaustive. A curiously unfounded theory, which was accepted for the best part of a century, identified it with the distinction between private and public ownership. The theory fell to pieces at the touch of Professor Vinogradov, and now, dark as the subject still is, it is generally accepted that Spellman was right when he identified full land with the holding of the ordinary peasant. More recent researches have made it appear probable that this holding was a share allotted by local custom, full right, in the common fields of the township, probably not as a fixed, separate possession, but as a shifting interest. BC land, as its name implies, is land, which has been made the subject of a written charter, or BC, and the few genuine charters of the period which profess to deal with alienation of land probably refer to this kind of ownership. It seems to have been specially connected with thainship. The Rectitudines speak of the thane's BC right in close connection with his land, and it is not unlikely that what the thane really had was jurisdiction, sacn, over a certain area, rather than what would now be called ownership. The ceorl's full land, on the contrary, was, probably, the land which he plowed and reaped by ancient customary rule. Thus, the same acre of ground might be the falkland of the ceorl and the BC land of the thane who was his lord. If so, it is clear that, even before the end of this period, a long step had been taken towards the establishment of that principle of tenure which today dominates our land law. For the thane's right could hardly come, ultimately, from anyone but the king, though it is possible that, even so early as the 10th century, a king's thane might have had thanes under him. Apparently, full land could be alienated, with shire witness. BC land might well be forfeited. Degree probably it could not be alienated without the permission of the donor. It was as much an office as property. Finally, if it be asked whether, in this early period there was anything which, without abuse of terms, may be called a law of contract or a law of tort, it must be answered that, if we insist on modern distinctions, there was not. But if we are content to look for primitive practices which may afterwards give rise to these modern ideas, we shall not look entirely in vain. For in the practices of giving, wed, pledge, or security for the performance of some act, or bore, bail, as surety for good conduct, we see undoubtedly the legal ancestors of the ancient contracts of pledge and guarantee. At first, it is probable, these practices were confined to the most urgent necessities of primitive law, viz., the submission to legal process and the maintenance of the peace. But we can hardly suppose King Alfred to have placed in the forefront of his secular code the supreme importance of holding one's wed, unless the wed had covered a wider range of duty than the mere delivery of oneself to justice. It is true that, along with breach of wed, Alfred classes breach of oath, but we know that, in later times, whatever the practice of the Church, the courts of the state refused to punish the lésio fidèle with a legal sanction. Of the very modern distinction which separates a breach of a promise from a wrong unconnected with contract, there is in this period no trace. Scarcely, as we have seen, are men beginning to draw the much earlier distinction between offenses which merely involve the offender in a family feud, and those which also draw down on him the wrath of the king, with its outlawry and forfeiture. Therefore the famous generalization of Sir Henry Maine hardly fits the facts of the Old English law, if indeed of any primitive system. The penal law of ancient England is not, to use the English technical word, a law of torts. It is a law which, with rare exceptions, recognizes merely the root idea of a wrong. It does not distinguish between crime, tort, and breach of contract. These sharp distinctions will come later on, but even when they arrive, they will overlap in a way which points conclusively to their common origin. Even at the present day, one and the selfsame act may be a crime, a breach of contract, and a tort. Now that we have looked at what the social contract is and have completed reading the 2 chapters on pre-English law, I would like to hear from you in the comments what information you did not know about before, and what information so far have you found the most helpful. I know the videos are not the best. I hope they get better quality over time. The into of the next video will be a quick review of both chapters on pre-English law before we get into the next era in law. Hey there! Today,